Mr. McHenry, there's been some discussion back and forth about the handling of minors cases, juvenile cases. There is, in fact, a set of rules and procedures that would apply to those types of cases, correct?
Well, we have, I mean, they're both, depending on the exact facts of the particular case, there's both law and regulations that would govern it. We also have an operating policies and procedures memorandum that gives additional guidance to the judges on how to handle juvenile cases.
Thank you. As a result of the fraud and abuse prevention program that you've discussed today, do you anticipate, with regard to asylum cases, that we'll see a further decline in asylum grant rates as a result of these efforts?
Again, I can't speculate because each asylum case is determined based on the evidence and the facts before it, so I can't speculate to what the future rates will hold.
There was a recent report issued by the Government Accountability Office that found that EOR failed on numerous procedures across the agency to adequately prevent asylum fraud in the adjudication process. We've talked a lot about that today. And they recommended regular fraud risk assessments across the asylum claims in the courts. You may have referenced this already this morning, but many of us have had to come in and out. Have you consulted the GAO's specific recommendations that they issued in that report?
I have. My understanding is my general counsel's office, they've completed one of the first risk assessments, and we're still reviewing the results of that.
So none of that's been implemented yet? Is that you're in the process of implementing risk assessments? Is that
My
right?
understanding is it's been conducted, at least the initial one, but we're still reviewing the results of what came back.
Could you get to us later a quick summary of what you find with that? I'm sure a lot of us would be interested in it. This is, personally, you were a former judge, and do you agree that judges face greater difficulties in assessing an individual's statements being true or not when they're not recorded electronically? Wouldn't that be a benefit to the judges to have electronically recorded statements?
Speaking as a judge, every judge I know wants as much evidence as they can possibly get.
And it is easier to determine, is it not, whether someone is being consistent in their statements if you have an electronic recording of what they've said prior?
I think that's typically correct, yes.
And you've testified earlier that those efforts are underway, that you're, I think the word you said, ramping up, or someone said ramping up the technology and what you're able to do in these proceedings.
In terms of our electronic filing and our electronic case adjudication, yes.
Does that also extend to the recording of statements? Is that something you're working on?
That's something that DHS would handle. We record our hearings, of course, but individual statements or anything that occurs outside of the hearing, I'd have to defer to DHS for that.